Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying civil procedure and I'm studying the amendments to the pleading under the rule 15. So this rule is actually very simple. All there is to it is what happens when a party makes a mistake. They can go back and fix that mistake by amending the pleading. And there's ways to do that, which I'll explain in a second. What they can do is they can ask the permission of the other party or they can ask the permission of the court. So what I'll be talking about in this video is amendments as a matter of course. Then I'll be talking about amendments with leave of court. And finally, I'll conclude with the relation back. I would like to read this rule for you real quick because this rule is very important, and this is the FRCP 15. It says that a party may amend a pleading once as a matter of course within 21 days after serving it, or if the pleading is one of which the responsive pleading is required, 21 days after service of responsive pleading, or 21 days after the service of motion under the FRCP 12. So the next thing I would like to talk about is a response required for an answer necessarily? No, if all it does is admit or deny allegations, and no if all it does is assert defenses. Yes, if the court orders a reply. I want to talk about the Rule 15 again. Over here, it says that when a party cannot amend its pleading as a matter of course, a party may amend its pleading only with an opposing party's written consent or the court's leave. The court should freely give leave when justice so requires. So what this says over here is that you can actually amend the pleading by getting permission from the other side, or you can ask the permission from the court if the other side does not consent. So I would like to give a quick example right here. So here's how this process works. The plaintiff files and serves the complaint, and then the defendant files an answer which advertently admits allegations in the complaint. Then the plaintiff moves for judgment on the pleading, but too late to amend answer without permission. And then the defendant must either get the plaintiff's consent to amend or make a motion to the court. That's what I was just talking about. And then the next thing I would like to talk about is the balancing factor. So what happens here is that the court actually balances to make sure that there's no harm to the opposing party or undue harm, undue delay, and also to make sure there's no bad faith or failure or futility of amendment. And finally, on the other side, the court will look at the amendments, aids, and decisions on the merits. And the last thing over here I would like to talk about is the relation back. So what do I mean by relation back? So here's how this works. For example, imagine on day 1, the plaintiff files a complaint but just forget some claims. What happens next? On day 2, statute of limitations passes on the omitted claims, and then on the day 3, the plaintiff adds omitted claims which relates back under the Rule 15. Finally, the added claim is treated as if it is included in the original complaint in the day 1. That's how this thing works. So I have a few other things that I've written here for you. I would like to talk about this real quick. So an example of this is when the defendant moves to dismiss for failure to state a claim rather than just to throw out the case. So when they move to dismiss for failure to state a claim, then the other side can amend the pleading. Also, you can look at the Rule 7 because the Rule 7 lists types of pleadings allowed, and also the time passed as a matter of course, then you get a consent from the plaintiff. That's what I just said. And also, allowing the amendments must be fair. So the court must be fair when they do this. And finally, like I just said, they must look at the unjustified delay, and they must look at the relation back, and it must relate back to the date that it was filed. So that's pretty much everything I wanted to talk about. All I just said was the amendments as a matter of course, amendments by leave of court, and the relation back. I really hope you enjoy studying. Good luck.